Hi, everyone. Welcome to VIISTA. I'm Jen White, and I'm an immigration attorney and also an adjunct professor with VIISTA. So today I'm going to present to you something I call Immigration 101. So it's just a very high-level overview of our immigration system in the US. Just bear in mind that I have tailored this presentation to teach more about nonprofit work. In other words, to prepare you to do nonprofit work like humanitarian immigration, for example. So I emphasize the humanitarian options a little more than like the business immigration options, for example. And also keep in mind that pretty much everything I tell you in this presentation is a generalization, meaning there's exceptions to pretty much everything I'll tell you. So let's go ahead and get started. Okay, so what are the sources of law in immigration? What's the authority we cite to as advocates? Well, the biggest source is the Immigration and Nationality Act. We call it the INA for short. And those are the immigration statutes passed by Congress that we rely on as advocates and that really set the standards for forms of relief for immigrants. And then we have the Code of Federal Regulations. We call them the regs, the regulations, the CFRs. There's different abbreviations we advocates use for those regs. And those basically add clarity and detail to the statute. So those are the two primary sources of law. But then we have additional sources of authority or law that we can also cite to and that also have formulated the law in the US. So we have international treaties that the US has signed on to and that obligate us to resettle refugees, for example. We also have executive orders. So we all know that the president has a lot of power over immigration. So the president can write executive orders that can vastly change the immigration landscape, really on a dime. Then we have case law, and there's different forms of case law. We have case law from the judiciary, like circuit courts, for example. And we also have case law that comes from executive agencies, like the Board of Immigration Appeals, for example. And then we have agency policy memorandums that aren't quite law, but they operate in such a big way that they can appear like law. Like, for example, because the executive branch has so much power over immigration, when the executive sets into place certain policies, agency policy memorandums are distributed and directly affect the way that immigration officers adjudicate a case. So I flagged that in here just because it's helpful to stay abreast of those policies and what's happening because things change so quickly in immigration. Sometimes it's just through a policy memorandum that was written by an agency official. So who decides immigration cases in our system? Well, I flagged here for you the three big ones. So we have USCIS, that's the US Citizenship and Immigration Service. And that's a big one you'll deal with a lot as an advocate. And under the umbrella of USCIS is the Asylum Office. So I'll get into asylum later on in the presentation, but it's helpful to know that the Asylum Office falls under the umbrella of USCIS. Then we have the Department of Justice, and that houses Immigration Court. And then we have the State Department, which handles a number of different matters within immigration, but the one you're most likely to interact with is the different consulates. So if you're doing consular processing for a client that's abroad, you're most likely to interact with the State Department through that form of relief. So these are the big ones you're likely to interact with, particularly if you're working at a nonprofit. So what is immigration status? This is a question I'm asked a lot, and I think the reason is that there's a lot of weird terminology in immigration in terms of what you hear on the news, what people talk about, what advocates say. And so I want to break down for you the way the law is actually applied. So I use the word status, and advocates in general, lawyers specifically, tend to use the word status to mean that the individual has permission from the US government to be present in the US. So most folks in the US have this status through birthright citizenship. So there's an interesting history behind birthright citizenship that comes through the 14th Amendment. So it's called the Citizenship Clause, and it actually came into being because Confederate states wanted to deny former slaves citizenship rights. So the 14th Amendment, and specifically the Citizenship Clause, was passed to acknowledge that former slaves absolutely had citizenship rights. And that's the way it was established legally, was that those folks were born in the US. So we have the same thing in place today. So generally speaking, if you're born on US soil, you are a US citizen. There's weird exceptions to this. Like, for example, one time I represented a family of 7, and the father was a diplomat from Yemen. So his youngest child was born in the US, but actually was not a citizen because the father was a diplomat. So he was actually a green card holder. So all that's to say, case in point right here, that there are exceptions to everything I'm saying in this presentation. So what does it mean to not have status in the US? Well, again, we have different terms for this. Some people say they don't have papers. Some people say the word undocumented to refer to someone who doesn't have status. Some people use the word illegal. Me personally, I don't really like these terms. I think the word status is more respectful. That's why I use it. However, I will say that in working with clients, a lot of people tend to understand the question, do you have papers? They know what that means, and it tends to translate well if you're using an interpreter or speaking in a different language. So I have formulated this presentation to show you the different levels of protection within our system. So you'll see that I mapped things out here using the image of a ladder. So the idea is that the different rungs on the ladder represent different levels of protection. Like, for example, deferred action, the second rung on the ladder, is better than having no status. Similarly, temporary status is better than having deferred action. So I didn't formulate this to show you like the different steps that immigrants have to take to get status. It's more to show you the layers of protection, because it would actually be very rare for an immigrant client to go through every rung on the ladder. So just keep that in mind. And the reason why I designated this into really 2 separate columns, you have alien and citizen, is because the INA distinguishes people in 2 ways. You're either an alien or a citizen. So you can see the different rungs on the ladder. Those are all alien statuses or alien, situations. And then we have the ultimate goal, really for everyone, is citizenship. So let's start out with that bottom rung, no status. How do people find themselves in the US without status? Well, there's a couple different ways. One, folks overstay their visa. So visas in general are finite. So they are set for a certain period of time. And if someone stays past the expiration date of their visa, then they're an overstay, we call them. They overstayed their visa. It could also be that the person didn't comply with immigration laws and regulations and they lost their status. Or it could be that the person entered illegally and just never had status. Bear in mind that there are harsh penalties for entering illegally. In many ways, I believe that this is disproportionate. It's an area of the law where we really need reform. And I'm saying this because, for example, if you overstay your visa, typically the penalties to you, like if you want to adjust status and become a green card holder, are far less severe than folks who enter illegally and go for the same thing, want to have a green card, want to apply for a green card. So just bear that in mind. It's an unfortunate hitch in our system that there are really harsh penalties for entering illegally. It's estimated that there's about 11 million people here in the US without status. So how can we help those folks? That's a lot of people. Well, some of those people are eligible for some form of relief. And that's one of the reasons why I'm giving this presentation. That's one of the reasons why I really believe in educating folks to get the word out so that folks know what they can apply for. But there's other ways to help even if someone's not eligible for relief. And what I mean by that is that the immigration laws as they exist right now are restrictive. They're complicated, they're restrictive. So if the laws don't change, if we don't see immigration reform, I would estimate that millions of those folks just will never be eligible for any form of immigration relief because the laws are just so narrow. But we can still help some of those people, and let me tell you how. One of the methods is through Know Your Rights presentations. So people who are here without status still have constitutional rights, and it's important that they know what those are. Like, for example, a lot of people without status live in fear of ICE coming to their door. Well, a lot of those folks that I've interacted with don't know that if ICE comes to their door, trying to pick them up and detain them and ultimately deport them, those folks have a constitutional right not to let ICE into their home unless ICE has a warrant with certain criteria. So I always explain to people, when I'm doing a Know Your Rights presentation, what that means, what they should ask of ICE if ICE shows up. And this can prevent a possible deportation. So as you learn about immigration law and as you become more comfortable explaining it to other people, I hope that you'll pursue things like that. I hope that you'll put on Know Your Rights presentations because they're really important. A second way we can help this population is by educating them to prevent notario fraud. So notario fraud is something that is a very sad reality in the US. Basically, people pose as immigration advocates or attorneys, and they tell people they're eligible for an immigration benefit, submit an application to the government, take all their clients' money, and then the person ends up in an even worse situation than they were before because a fraudulent application is a big deal. Our government then knows where this person is, could come after them. Whereas before, oftentimes folks are under the radar. So when people are educated and they know, okay, I'm not eligible for anything right now, they're far less likely to be exploited by someone who is pursuing notario fraud. So how do people get immigration status? This is really the big takeaway of this presentation. This is what I want you to remember when you are out in the field and helping clients. There's three big buckets or categories for immigration relief generally. You have business and academic, you have family-based, and you have humanitarian-based. And I'm saying this because I've interacted with a lot of clients over the years who are eligible for more than one form of relief. So it really helps as an advocate to kind of pull back and really still maintain a high level view of the system, because maybe you could submit 2 applications for one person, and that only increases their chances of ultimately getting status, right? So I hope that you'll remember these 3 categories and keep them in mind in the future when you're screening clients. So what is work authorization? Another big question I get from people a lot is, Jen, I'm not interested in a green card. I don't even want to stay in the US that long, but I want work authorization. Can you help me get work authorization? So work authorization is usually tied to an immigration benefit. So in other words, if someone doesn't have status or doesn't have an application for status pending, generally they're not eligible for work authorization. So to say that differently, basically, while an application is pending for an immigration benefit, sometimes there's a possibility of getting work authorization while it's pending. But oftentimes an immigration benefit will come with work authorization. So it's important to know that sadly, millions of people in the US right now just are not eligible for work authorization because they don't have anything pending and they're just not eligible to actually submit an application in the first place. So just remember that generally speaking, work authorization in the US is tied to an underlying immigration benefit. Okay, we're moving up the rungs of the ladder. What is deferred action? Deferred action is pretty simple. It's just a promise not to deport for a certain period of time, and then work authorization for that same period of time. So the most popular form of deferred action is DACA, Deferred Action for Childhood Arrivals. So depending on when you watch this presentation, there's been a lot of litigation, so many different changes that have come into effect with DACA. But basically, the criteria is all listed here on this page. You have to have entered prior to the age of 16, entered prior to June 15th, 2007. You have to be living in the US without status when the announcement was made in June 2012. You have to be a graduate of high school, GED, or enrolled in school. And there's some criminal bars. So if you have an aggravated felony, for example, or if you've committed several serious crimes, like more than 2, you're not going to be eligible for DACA. And DACA is discretionary, which means that it can be denied even if you meet the criteria listed here. So like, for example, I represented someone once who had a trespassing charge, not a trespassing conviction, just a charge. And so she actually was not barred, like under the criminal bars as they exist here. She wasn't barred from getting DACA, but the government still denied her case because it was discretionary, and they didn't like that there was a trespassing charge on her record. But generally speaking, these are cases that I would say are easier to win than a lot of other immigration cases. They're a little more straightforward. So a lot of nonprofits handle these, a lot of law firms, pretty much any immigration advocate that works in legal services knows how to do a DACA application, and they are pretty simple and straightforward. Okay, we're moving up the ladder again. What is temporary status? Well, the most common form of temporary status are the non-immigrant visas. So non-immigrant just means temporary. So these are finite period of time visas. There's a whole bunch of different types of visas. We call it alphabet soup visa options because they're all, for the most part, either a letter or a letter and a number to describe the visa type. So here's some common examples for you. We have a B1, which is a business visitor visa. We have B2, which is a tourist visitor visa. Then we have the B1, B2, which is a combination of those two things. And then we have H1B, which is a specialty occupations and fields requiring highly specialized knowledge visa. We have the F visas, which are for students. And then these last two here are humanitarian in nature. So you're more likely to see these, in a greater volume in a nonprofit setting. So the U visa is for victims of certain crimes who help law enforcement investigate or prosecute crime. So there's an interesting policy explanation for the U visa. Basically, in the early 2000s, Congress recognized that a lot of immigrants were hesitant to report crimes against them to law enforcement because they thought that doing so could lead to deportation. Basically, they'd be coming forward to a government agency, exposing themselves, exposing the fact that they didn't have status, and they didn't want to do that, so they just wouldn't report crime. So Congress recognized that was a huge problem, and that's why the U visa came into being, basically to sort of provide an incentive for immigrants to report crime by giving them status if they helped with the investigation and prosecution. And then the T visa is a trafficking visa. So it's for folks that satisfy the federal definition of trafficking. So it's either labor or sex trafficking. And they're in the US on account of trafficking. So the T visa is pretty technical. And it is the only government benefit that I know of that is underutilized. So what I mean by this is that Congress has allocated 5,000 of these to be given out every year. But every year, we only have 1,000 or 2,000 applications, and even fewer of those are granted every year. So it's a real shame and really speaks to the vulnerability of immigrants who are trafficked, that they are so removed from advocacy and services that we don't even have, the same amount of applications as we have slots allocated by Congress to be given out. So T visas, my hope is that there will be more advocates over time really trained in T visas so that we can help meet that need. Another form of temporary status is temporary protected status. So this is when the US government designates countries as too dangerous to return to. And there's 2 reasons why the US government designates countries as too dangerous. It's either armed conflict or natural disaster. So TPS means that you get work authorization and that you're not removable or detainable for an immigration status. And you can also get a travel document if you have TPS, meaning that you can travel abroad. So permanent status, we have arrived toward the top of the ladder into permanency, which is a great, great thing. That's what we are trying to help clients get to. So permanent does not mean permanent in US immigration law. It's helpful to know that. It means probably permanent. And I say this because all permanent statuses in immigration are revocable. So when you get permanent status for a client, when you help them succeed on those applications, it is joyous. I can tell you, it is a wonderful feeling. Your clients are often just shocked and overjoyed, and it's really a beautiful thing to share that with them. But I can tell you the reason why I'm flagging this for you is because you want to know how permanent status can be revoked. So that way you advise your client so they know what to be aware of, so they don't, God forbid, lose their status. So what are the common forms of permanent status in the US? Well, there's 3. We have lawful permanent residency, and that's another word for being a green card holder. And then we have these other 2. We have asylum and refugee status. And both of those can lead to lawful permanent residency. That's why I created this kind of diagram the way that I did. So for example, 1 year after having asylum status or being granted asylum, you're eligible to apply for your green card for lawful permanent residency. But these are the 3 big ones. These are 3 permanent statuses. So lawful permanent residency, having a green card, what does it mean? It means you can work legally, you can travel internationally with restrictions. So the big restriction I always tell clients when they get their green card is not to stay out of the country more than 180 days, because that can lead to some inadmissibility problems. So one of the complications you'll hear about in immigration law is this idea of inadmissibility. And it's really kind of a fancy way of saying like a bar to immigration or a bar to status. So when folks travel for over 180 days, the government can, start to question whether or not this person intends to keep their permanent residency in the US. In essence, tends to question the person's loyalty to the US and can make it hard for that person to keep their green card. So that's just a good warning to know about, so you can share that with clients, that they should not travel for more than 6 months out of the country if they have a green card. They can be eligible for certain public benefits depending on the state where they live, and they can sponsor family members. So a green card holder can sponsor their immigrant spouse or immigrant children, again with exceptions and restrictions. So for example, if a green card holder wants to apply for status for their child, it matters how old that child is and if that child is married. So again, remember the laws are restrictive. Remember that these broad categories usually come with some restrictions. Can you lose your green card? Yes, you can. There's 2 ways. One, you can voluntarily relinquish it. Say you're done with this country, you want to live elsewhere, voluntarily turn back in your green card. Number 2, an immigration judge can strip you of your green card. So usually that is a result of certain crime or fraud. Those are the big options I've seen. So what that means is, say you're a green card holder and you are convicted of a pretty serious domestic violence offense, for example. The government, depending on, certain things, can initiate removal proceedings against you. And then if a judge adjudicates the case and decides, okay, yes, like this offense satisfies the immigration laws in such a way that your green card is now revoked, enters an order that the green card is revoked, then obviously you're removable at that point. You don't have your green card anymore. That's the second way, is that an immigration judge takes your green card away from you. But notice that it takes an affirmative process by the government, meaning like the ICE attorney would have to file this case, right, and make the case against you, and a judge would have to order that your green card is taken away. It's not some sort of like automatic thing. The government actually has to initiate removal proceedings against you. So how do you get a green card? Well, I'm coming back to my 3 buckets again. Remember the 3 buckets. This is just like pretty much anything else in immigration law. There's 3 routes to getting your green card. You have the business academic route, family-based route, and the humanitarian-based route. So let me just give a really quick overview of family-based. Again, remember, exceptions to everything I say. A U.S. citizen can apply, petition for their immigrant parent, spouse, or child. Remember what I said about children. It matters how old they are and if they're married. The visa bulletin also sets in place different categories. It basically categorizes people based on the country where they're from and limits how many people we can let into the US based on where they're from. So it's called the visa bulletin. You'll learn about it in VIISTA and also when you're in the field. And then a green card holder, like I mentioned, can petition for their spouse or their child. So those are the family-based options. So like, for example, people have come up to me for years and said to me, hey, can I petition for my cousin? No, like that is not a family relationship that's acknowledged by the US immigration law as a basis for a family petition. So another small option, very, very small bucket, is the diversity visa lottery. So I've personally never had any success for a client through the diversity visa lottery, but folks, if they're from the designated countries, can apply. So it's just good to know about. Now I put in here a little flag for myself to remind myself to explain to you what VAWA is. So VAWA is the Violence Against Women Act. It is a poorly named law because it doesn't just protect women, it protects men, women, children. And I situated VAWA where I did, in between the family and the humanitarian buckets, for a reason, because humanitarian immigration options, it's kind of self-explanatory. It's humanitarian because basically the laws are rooted in mercy rather than some other policy reason. Like with the business academic options, the policy reason is that we want to attract talent into the US. That's why we have those options. The family-based options exist because the US values family, wants to keep family together, and that's why we've created these pathways for family. Well, the humanitarian options exist because we want to be a society that recognizes mercy, that some people have been through so much that we just want to acknowledge their suffering and give them some reprieve. And that's really what the humanitarian options are all about. So VAWA, I situated that between the family and humanitarian buckets. Why? Well, because VAWA is kind of a hybrid form of relief. So when I explained to you family-based immigration, common application type for that option is US citizen husband petitioning for a non-citizen wife. Well, when that happens, you'll notice that the husband has all the power, right? Because he's firmly planted in the US. He's a citizen. That's not a revocable status generally. And he's petitioning for his wife, so he has all the power, right? She has very little. She's completely reliant on him, and he has very little to lose. Well, when abuse enters that kind of relationship, can really complicate things and sort of exacerbate those pre-existing power dynamics that are a result of our immigration laws. So what I'm getting at is that VAWA, a classic example of a VAWA case, would allow that woman who is a spouse to a US citizen to petition on her own, a self-petition, pretty much based on the abuse she suffered by her US citizen husband. So I'm simplifying this a bit, but you can kind of see how VAWA exists to sort of level the playing field for that the victim of abuse, so that she doesn't have to be so reliant on husband and continue to endure abuse, so that she ultimately gets immigration status. So there are different types of VAWA cases, but that is kind of the classic VAWA example. So helpful to know about when you're screening clients. Okay, asylum and refugee status. What's the difference? Why do we have these two forms of relief? There's a lot of confusion about this, I find. Well, an asylee is someone who applies for humanitarian protection once they're in the United States. A refugee is someone who applies for humanitarian status abroad, outside of the US. But the legal definition is the same. So I've written out the actual legal definition here. I took it from the statute directly, but I'll give you kind of a simpler explanation, just the way I like to think about asylum and refugee status. So the legal definition is that you either suffered past persecution or you have a well-founded fear of future persecution on account of one of 5 grounds. So race, membership in a particular social group, political opinion, religion, or national origin. That's what the definition is. Same definition for asylees and refugees. So let's get into history a little bit. How did we get this definition for a refugee? And again, the way the law is written, so to qualify for asylum, you have to satisfy the legal definition of a refugee. So that's why I'm explaining this the way I am. Same definition, we just say it's the legal definition for a refugee. So after World War II, the United Nations created several treaties to protect refugees. So it was basically an acknowledgement of the horrible reality that Nazi Germany created all of these displaced people who needed to resettle elsewhere. So the UN created this treaty called the 1951 Convention Relating to the Status of Refugees. For short, I call it the Refugee Convention. Advocates refer to it as different things, but I think Refugee Convention is the most common. So this Refugee Convention created a legal definition for a refugee that's very similar to the definition I just explained to you. And basically said, hey, if you're going to sign this treaty, you are obligated to protect refugees, people who meet the legal definition, want to settle in your country, you need to help them, state signatories. So the US did not sign on to that treaty. However, the US did sign on to a subsequent related treaty called the Protocol Relating to the Status of Refugees. I call it the 1967 Protocol for short. And basically, that second treaty provided further clarification about what that first treaty meant. So it incorporated the legal definition of a refugee and just gave some more detail. And the US did sign on to that treaty, meaning the US is legally bound through this international treaty to resettle refugees. So this is why when you see on the news advocates talking about, we have an international obligation to protect refugees and asylum seekers, this is why. It's rooted in international law that has been in existence for a long time and really has evolved in our own domestic system. So for example, the Refugee Act of 1980 incorporated this definition of a refugee into our domestic law and ultimately the INA. So I think the history is important because this is something I've relied on a lot when I'm making arguments that asylum law, because I represent asylum seekers, I don't represent refugees because I work in the US and not abroad. Asylum seekers are seeking a form of relief that has been in existence for decades, has taken a lot of work to implement. So I think sometimes the conversation around this form of relief is makes it seem like asylum is something that, is new or is generously given out, when in reality it's actually very hard to get asylum, and it's a form of protection that's really deeply ingrained into our system and came about because of the worst atrocity our world has really seen in quite some time, World War II. So I think history is important, and I hope you'll read up on that and educate yourself about the way our system developed to protect asylum seekers and refugees. So what happens at the border? This is another question I get frequently. Like, what's the process when people come through the southern border? What does that look like? Well, the migrant protection protocols, we call it MPP, drastically changed the way processing happened at the border. So I'm not going to get into that. What I'm actually going to walk you through is the system that was in place for a long time before MPP, so before Trump implemented this Remain in Mexico policy. The MPP and Remain in Mexico are synonymous. So I'm recording this in July of 2021, but I'm flagging for you what many clients have gone through when they entered the southern border. You're likely to come into contact with a ton of clients who went through this process I'm about to describe. Just bear in mind that it might not be what's actually in place when you're helping your clients. It's just helpful to know, kind of the general pathway. So what tends to happen is that the client crosses the border, is apprehended by CBP, Customs and Border Protection. And if they express a fear of return home, like they're being persecuted, they fear torture, etc., then they're entitled to what's called a threshold interview to determine if they can gain entry into the United States. Now, they're detained during this period of time, but like I said, they're entitled, if they express a fear of return, to an interview to assess whether or not they can come into the country and apply for a form of relief. Well, what are those threshold interviews? What does that mean? I'll explain. Well, first of all, they're conducted by an asylum officer, so someone who has some level of training on how to interview someone who's been traumatized, what kind of legal analysis they should be applying to make this determination, whether or not this person should be granted entry or not. But there's two types of interviews that you could get at the southern border once you express a fear of return. The first is a credible fear interview, a CFI, we call it. And this threshold interview is to assess whether or not there's a significant possibility that you could win an asylum or related case type. So if the asylum officer decides that, yep, there's a significant possibility you could win on an asylum or related case type, you can be eligible for release, for bond. Now, the other type of interview you could get once you express that fear of return home to your country is a reasonable fear interview, an RFI. And the folks that receive the RFI receive a different type of interview because they either entered the country before and they were deported, or they have some sort of criminal history that makes them eligible for the RFI instead of the CFI. And the threshold there is higher. You have to show a greater than 50% chance of torture or persecution in your country. So the folks that get the RFI are not eligible for asylum, but they could be eligible for something called withholding of removal or protection under the Convention Against Torture. So in either case, with the CFI or an RFI, the individual is then eligible for bond, hopefully. Again, exceptions to that, but hopefully they're eligible for bond and they can get out of immigration detention and ultimately work on their case. Now, some folks can be eligible for parole once they pass that threshold interview, but I've never seen this happen personally, so I'm not going to talk about it. I'm going to talk about bond because that is what's more common. So how does someone get bond? Like, how do they win on a bond case? Well, it's a two-pronged argument. The immigrant is tasked with proving that they're not a safety risk and that they're not a flight risk. And then if they succeed on that bond case, they're granted bond, they pay their bond, they're released. The monetary minimum for bond is $1,500. Historically, we've also had some non-monetary conditions like an ankle monitor, meaning that the person didn't have to pay money to get out on bond, but they were given an ankle monitor that they had to charge up and then use to like check in with ICE so that the government always knew their whereabouts. So very inconvenient because they need charged a lot, but kind of nice in the sense that the person wasn't out a lot of money at the same time. So once all of this is done, and this is, it's a lot for a person to go through, that's when they're actually released and the removal proceedings commence. And so what that means is that after the person gets out of immigration detention, at some point around that time, they'll get a notice saying that they need to appear for their removal proceedings. So that would be a master calendar hearing where they have to appear in front of a judge and really start making progress on their case, like what form of relief they're going to apply for. Usually it's asylum, withholding, or protection under the Convention Against Torture. So let's get into the asylum application process. There are two forms of asylum applications. So you have affirmative and defensive. So defensive asylum is for the folks that I just explained. Folks that are in immigration removal proceedings, they're appearing in front of an immigration judge, right? ICE is actively trying to deport them, even though they were just released from immigration detention. Those folks apply for defensive asylum, meaning they apply in front of the judge that they're appearing in front of. Everyone else would apply for affirmative asylum. Like if you don't have active removal proceedings against you, you apply with the asylum office. So you remember USCIS is the big umbrella agency, and then you have the asylum officer, the asylum office under that umbrella. So there's some pretty big differences between the two processes. Affirmative asylum is completed by an asylum officer that's trained in interviewing, and it's less adversarial in nature. So you go up, to this government office, and you're not dealing with a court scenario, you're just dealing with one person. So if the immigrant is represented, it'll be, them, and then their advocate, and then the asylum officer, and that's it. Defensive asylum is different. It's honestly more intimidating because it's in a courtroom. So you have a judge, you have the ICE attorney that's prosecuting the immigrant, you have the immigrant, and if they're represented, their advocate. And in a defensive scenario, it's more stressful for the client because they're going to be cross-examined by ICE. There's a judge there that's likely going to interrupt their direct examination. So it's just a completely different setting. So after an immigrant submits their application for asylum, either in front of the judge or with the asylum office, they have the right to remain in this country until their asylum application is adjudicated. A lot of people don't know this, so I like to tell my clients this. So like, for example, after I submit an asylum application, I like to give my client the receipt notice and tell them, look, like you have some peace of mind now. Here's the receipt notice. You can carry with you in case, you're stopped by ICE or something, or the government ever gives you a hard time. You can pull out your receipt notice and say, no, I have the right to remain in this country. I have an asylum application pending. So asylum applications can take many years to process. The quickest I've seen an asylum application be processed in the last couple of years is a year long, so a year-long wait. And the longest I've seen is about 15 years. So it's really unpredictable. And oftentimes there's just nothing you can do to speed up the process. So some folks can apply for work authorization while their asylum application is pending. This used to be a pretty straightforward area of the law, that person would submit an application for asylum and then 150 days later, they could apply for work authorization. But that rule has become far more complicated because the Trump administration changed that rule and added a whole bunch of criteria to it. So it's not that simple anymore. Not everyone is eligible to submit an application for work authorization while their asylum application is pending. That rule is actually subject to a lot of litigation that's pending right now. So depending on when you watch this, it's probably worth looking up the status of what's going on with that rule and the litigation. So affirmative asylum. So I explained to you a little bit about what that means. It's a non-adversarial interview. It's very different in nature than a judge adjudicating an asylum application. Well, one thing that's important to note is that unaccompanied alien children, and that means kids who are in the US, who are under 18, don't have a parent or legal guardian in the US available to care for them. That's what a UAC is, unaccompanied alien child. Those kids are all eligible to apply for asylum with the asylum office. So they're eligible for that non-adversarial interview. And there's obviously a good policy reason for this, right? We want kids to be in a less stressful environment when they're applying for asylum, especially kids who have no support and who are here without any parents or legal guardians. I'm flagging this for you because I represented a number of kids who crossed the southern border. They were detained and they were released. And all throughout that time, they didn't have parents with them. So they were very clearly UACs, right? But the government still put them into removal proceedings, even though, like I just mentioned, the asylum office actually has jurisdiction over their claims. I'm saying this because it is up to you as the advocate to file asylum applications for these kids with the asylum office, not the court, right? You have to make the argument, the legal argument, that the children you're representing satisfy the definition for a UAC, and therefore that the asylum office has jurisdiction. It's very easy to, assume that the government has things right, because like in this scenario, if I would have just assumed my clients were, supposed to go in front of the immigration judge, like the government told them, I would never have filed with the asylum office. I would have filed with the immigration judge. But it's much better for children to interview with an asylum officer than to appear in court, which is, an intimidating scene for most kids. So always remember that UACs should always appear in front of the asylum office, regardless of what the government says. The onus is on you to make that argument. So defensive asylum, as I mentioned, defensive asylum is just court. It's where you apply for asylum in court. So you'll notice the way I kind of mapped out this screen here. Hopefully you can see it. You have the immigrant and the advocate on one side of the courtroom sitting at their table. We call it counsel's table usually. On the other side, you have opposing counsel. So that's the OPLA attorney or the ICE attorney. Again, we have different names for these attorneys, but OPLA is the Office of the Principal Legal Advisor, and that is a sub-agency of ICE, Immigration and Customs Enforcement. So basically, that's just the government attorney that's trying to prosecute your client, essentially trying to deport your client. And then you have the judge who's adjudicating the case. So note that both of the other people in the room, the judge and the OPLA attorney, are executive agency officials. I flag this because you can kind of see through this demonstration here, through this visual, how the odds are really stacked against the immigrant, right? You have two government officials from the same branch of government sitting in the room under a lot of pressure, policy pressure, most likely to deny the client's case. So hopefully this will motivate you to want to do something about that and want to provide in-court representation. I actually just had a client go in to observe court hearings. I'm sorry, I had a student go in to observe court hearings. And I asked him what he thought, what his impression was. And he said to me, well, I really feel like I could do this. I feel like I could answer the judge's questions that he asked of the immigrants who were unrepresented, representing themselves. I feel like I could handle that. Like the issues that those folks faced because they didn't have an advocate were enormous. So I feel like I could do that. And that was absolutely music to my ears. I think that is exactly what we need. That's why VIISTA exists, to prepare you to do this kind of work. And I hope that you will see this power differential and really want to get involved and be an advocate. Okay, so last rung on the ladder is citizen. So this is really the goal for pretty much every client you'll represent: citizenship. So citizenship and naturalization are pretty much synonymous. Naturalization is the process that the person goes through to apply to become a citizen. So in actuality, when clients are asking me when they have a green card, do I really need to become a citizen? Like, I'm fine with my green card. Well, what are really the benefits of me applying? Because it's expensive. It's over $700 to apply, unless you can be eligible for a fee waiver. So that's a lot of money and sometimes a deterrent for clients. Well, the benefits are as follows. You can vote. You don't have to live in fear of deportation, which is wonderful. And you don't have to deal with US immigration any longer, or, deal with the lawyer or the advocate. A lot of times immigration is so stressful for people that they're just relieved not only to be a citizen, but to be free from the process and having to deal with me or other advocates. One small exception: citizenship is generally not revocable, but there have been a few instances of this for folks who were involved in like Nazi activity or terrorism. The US government has revoked citizenship, but it's extremely rare. So in a nutshell, that is our immigration system. I hope that this was helpful for you and that you leave here with kind of a working framework that will help you see the big picture and especially help you interview clients when you're trying to determine whether or not they're eligible for a benefit. Remember those 3 categories: business, academic, family-based, and humanitarian. And I wish you well.